Hi, and welcome to the AdaKay Show. I am AdaKay Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Hello and welcome. We're back. Hello, everybody. I'm AdaKay, and we are back. It has been a day. This is my third live of the day, and I have one more to go. Today has been crazy. We did the P. Diddy. We've done the Kohlberger. Now we're on the Sterns. So now we're on Stephan Sterns, and he's supposed to be live with a pretrial. I don't see the live up yet, but I do know that there are 3 channels who are supposed to be covering it. Hello, Miss Lippy. Oh my gosh, it has been a while, beloved. We have missed you. Lovely thumbnail. Love, love, love the thumbnail. So while we're waiting for this wonderful hearing to begin, we need to do a quick review. How about that? Because it's been a hot minute since I've talked about Sterns. So, what is he charged with? Stephan Sterns is accused of the actual abuse of and the red room of a 13-year-old girl by the name of Madeline Soto, which we've heard a lot about in the news. His girlfriend's daughter. He faces 60 charges related to actual bodily molestation and the possession of CP. I am changing the words a little bit because I don't want to get in trouble with YouTube. So he has pled guilty, of course, on all charges. The actual abuse trial was originally scheduled for May, but has been delayed multiple times. Now is expected to begin later this month. The pretrial hearing is taking place today, focusing on the admissibility of evidence, particularly the data from Sterns' cell phone. It shouldn't have already taken place. Oh, sorry, guys. My ears were not properly installed. It should not have already taken place. I'm looking for today's appearance. No, it has not happened yet. Everything is talking about it happening today at 1:30. So we do not have it as of yet. Okay. So, evidence. The law enforcement accesses Sterns' phone without a warrant, citing urgency due to the alleged attempt to destroy the evidence. That is kind of sort of a bone in this case right now. I do know that they can access certain technology devices without a warrant, but that said, it's under extreme circumstances that they can do so. Sterns claimed he gave them limited consent, specifically to check Google Maps and login status. His defense argues the search was coercive and unconstitutional, and they are pushing to have the phone evidence excluded. Now, what is the key evidence in this case? The investigators reportedly found CPX material on his phone. Surveillance footage allegedly shows a man matching Sterns' description moving in what appeared to be a limp body into the truck. Stern told investigators he dropped Maddie off near the school the day of the disappearance, but the school official said she never made it or arrived. The Red Room trial is scheduled to begin in September. The judge has not yet ruled on whether the disputed phone the disputed phone evidence will be allowed in the actual abuse. They are trying this in multiple levels. There are so many charges that they are trying the actual XSA part of the case first. This has been a very hot case, but a lot of public scrutiny has been going. It's not just because of the horrible nature of the case, I should say horrible nature of the case and the allegations, but the legal questions that it raises about the digital privacy, consent, due process. That is where we stand on this. So we are waiting patiently, waiting. So why don't I, that's 45 minutes, that's 11 minutes. I'll play this.
About this yesterday because of that suppression hearing where the judge is going to be considering whether or not to allow evidence.
June, I've not seen this June in quite a while. Hello.
Specifically concerning from the cell phone of Stephan Sterns. This is in the sexual battery case that was originally slated to go to trial May 5th, that is now scheduled to go to trial in July. So a lot of interesting things in court yesterday, and as this case kind of moves forward. Joining us live now via Zoom to talk about this is Lauren Cadillac, who is an attorney, the owner of Cadillac Law in Dallas, and also someone that we've spoken to before, specifically when we were talking a lot about Sarah Boone. And so, Lauren, we appreciate you joining us from Dallas this morning.
Thanks, Garrett. It's great to be here, and I appreciate it. Good morning.
Good morning to you. I know this is a case that you are also following closely. Just kind of give me your reaction, initial thoughts to the hearing yesterday. Went on for several hours as we heard arguments from the prosecution and the defense as to why this.
My gosh, we got people we've not had here in a hot minute. We got Libby, we got June, we got Tash. Tash,
Evidence from Stern's cell phone should not be admitted into court.
Well, first, it goes a little deeper than just the cell phone. The suppression motion asked to suppress Stern's cloud file, which, if you've been following this case at all, you know contained thousands of photos of him and Madeline in positions that no parent would want for their child.
No.
So it is important for the defense to try to get that out because that is the prosecution's case primarily. So here, the defense argued that, they made a fruit of the poisonous tree argument. Okay, so they said, look, you got this phone, you didn't have consent, he was technically detained, you didn't, get the proper warrant, and anything that stems from the phone onward, including the data you retrieved because you knew about the stuff, because you knew the phone information, all of that needs to be suppressed. I think it's a good argument on the defense's part. And I think the judge taking time to consider and make his ruling shows that the defense made a good argument. It was especially poignant to me yesterday when the judge asked witnesses questions. And when you're sitting in a courtroom and a judge asks your witness something, based off that question, you can kind of know where the judge's opinion is going. So it will be interesting to see how this judge rules. I tend to think because he handed the phone over, he sat there while they searched through it, he never protested. I tend to think the phone information will be allowed, but maybe some of the information that followed would not.
And what impact would that have? I know you said this is a major major evidence in this case, specifically the sexual battery case, which is what at issue here. What else is there if that is some of that is thrown out?
Well, that's exactly the point. And that's why the defense is even moving to suppress this evidence. If this evidence is successfully suppressed, unless the prosecution has something else that we don't know about, these charges would basically have to be dropped. There's no way to prove beyond a reasonable doubt without all of that cloud data. Although I know there were some jail phone calls between Stearns and his parents, and those are somewhat incriminating. They could help. I don't think the phone calls themselves would prove beyond a reasonable doubt, and certainly not in the way that, hey, this is his cloud, these are his photos, gee, look how gross these are, would.
From your perspective as an attorney, we know these, motions like these are fairly common especially in cases like this that we follow. But from what it sounds like, some of the reaction necessarily from the judge is not something that we always see in things like this, as far as, like you said, him asking some questions of the witnesses, and then also taking nearly 2 months to kind of look over this and make a decision on this.
Yeah, it is interesting. We don't usually see the judges, well, in watching criminal prosecution online, we don't see judges ask questions. They do it all the time in civil court. But it is interesting to see that, and particularly the questions the judge was asking. He was asking the police about, the possession and searching through the phone, and his questions, though I don't remember his exact wording, they made me sit back and go, is he going to lean towards suppression? It is a very good argument the defense is making using the fruit of the poisonous tree. And that's the idea that if you obtain one thing legally and that thing leads to other things, all the other things are also obtained illegally, as they are fruit of the poisonous tree of the start of the illegal search. So it is a good argument on the defense's side. I thought the prosecution did really well in their questions, but based off the judge's questions, it did seem he was leaning a little towards the defense. I'm thinking that because of who the victim is here and the type of crime he's charged with, the judge would like to use an abundance of caution before before making his ruling. And so he's probably going to go back and read all the case law that they provided. He's probably
Okay, guys, I'm trying to find the link. I do know it's supposed to be live. It was supposed to be televised live, but I'm not finding the link. If anybody has any ideas, that would be grand. That would be grand.
going to go to his law clerk and ask them to do some additional research and kind of allow all of that to help him make his decision. And that is great. We don't want judges making decisions off of their feelings. Okay, that's not a judge's role. Feelings don't matter in a courtroom. And so a judge who's willing to step back and go, wait, let me check the law. Let me make sure I apply these facts to the law that is controlling in this case. That is exactly what we want to see out of our judiciary.
One, especially in a case like this that he knows is being closely watched, and knows that there are certain things that potentially could be under scrutiny in future appeals as well.
Exactly. I mean, this crime it's disgusting. It's gross. It's every parent's worst nightmare. And the judge is aware that his constituency feels that way because, he probably feels that way. Now, even though a crime is horrific and disgusting, as someone who is on American soil, you don't have to be a citizen, but if you're on the soil of this great land, you get due process. The Constitution applies to you, and the government has to obtain their evidence through legal means. So it doesn't matter how disgusting the person behaved or how completely shocked you are by it, and we'll say is alleged to behave, because it has to be proven that they behaved that way. What matters is that you are on American soil and our Constitution applies.
Well, and the onus to prove that this Is the onus, when it comes to these suppression hearings, just for everyone's knowledge so we're on the same page, is the onus on the prosecution to prove that this evidence was obtained lawfully, or is the onus on the defense to prove that it was obtained unlawfully?
So in these situations, there is burden shifting. The defense has an initial burden, and once the defense shows that that could possibly exist, then the burden shifts to the prosecution. Then the prosecution has to show how it did not exist or how it was not illegal. And they did actually do some discussing in the hearing yesterday about the shifting burden, etc.
It's going to be interesting to watch either way as we kind of look ahead to the things that are going to be happening. We've got the timeline that I can pull up here. June 30th is when the judge says he will have that written ruling out by July 2nd, the pretrial hearing, July 14th, the jury trial slated to begin, and then the September 22nd when the capital murder trial is slated to begin. So going to be a busy summer for the legal team.
Yeah.
Oh,
if
hello,
I were
puzzle
one of the
pieces.
attorneys, I would not be okay with this. If I need pretrial hearings by July 2nd, that's 3 days after the judge's ruling. How am I going to know? I mean, that's like, there's a lot hanging on this evidence in particular. And so I think, I think it's great to use an abundance of caution, but 3 days before your motions in limine need to be argued it does not seem prudent or just to me. Like, that really makes your defense team and your prosecution, everybody is going to have to go do this crazy dance for 72 hours. And who knows, if they'll actually be ready on the 2nd. That's a weird timeline when I review that.
So then you think if it is, if the judge does take that full time and doesn't come out with that ruling until June 30th, there could be a chance that trial then gets pushed back again?
Well, if he comes out and says the evidence is suppressed, then the prosecution is going to appeal that ruling, right? If he comes out and says this evidence is allowed in, then the defense is going to say, well, I need more than 72 hours to write my motions in limine to address all these other things, right? And I think it's kind of a lose-lose. Like, no side is going to be prepared 3 days later. If they are, congratulations, you guys have figured this work-life balance out beyond belief. But I can't imagine a world where your counsel could be prepared that quickly.
All right. Well,
all right, guys. Well, guess what? We're not going to be able to have access. There's no stream. Thank you very much.
I want you to see if you like it.
Okay. My son got me a sandwich. No, I don't like lettuce, Matt.
Well, I know what it's on.
But I don't like lettuce. Well, I like lettuce. I don't like shredded lettuce on a hot sandwich. Just doesn't seem to compute with me. It just, nasty. All right. So I tried. We're not going to be able to have any video of it. My apologies to you, June, Puzzle, Tash, and Libby. I am so sorry. It's a gyro from Arby's. But anyway, it looks like we're not going to have a video. My apologies. I am so sorry to get you all excited for nothing. So I'm going to go ahead and break this live. I'm going to go have lunch. And then be back here at 5 o'clock, y'all. If y'all want, be back here at 5 o'clock. Because we're going to start with the Karina Cooper trial. We're going to start there. I know it is good. I'm so sorry, guys. I hate to disappoint you, but I don't have video feed for this. So if we should get a video feed at some point, we'll come back in. But I am so jam-packed today. I really need to take this time to eat, go to the doctor, get lab work, and get back here by 5. Okay. So y'all are awesome. I appreciate you so much for joining me. Y'all have a fabulous afternoon. I will see you in a little bit. My apologies. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.